Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Bostock v. Clayton County. This case was heard in the Supreme Court of the United States in the year 2020. Let's go ahead and jump into the facts of the case. So Bostock was a man that was working for Clayton County. He started working there in 2003 as a child welfare services coordinator. In 2013, he made the decision to attend a gay softball league. When he came back, his coworkers and his supervisors got wind that he had attended a gay softball league, and they essentially harassed him for a little bit, and then he was terminated from Clayton County. Clayton County said that they terminated him because he had conduct that was unbecoming of an employee. So they didn't directly say they terminated him because he was gay. They just said that some of his conduct was unbecoming as an employee. Well, Bostock felt like he was terminated because he was gay, and he felt like this was wrong. So he looked to Title VII of the Civil Rights Act, which prohibits discrimination in employment based upon race, color, religion, sex. And sex is the word that we focus on there. Bostock is alleging that his termination by Clayton County was a Title VII violation because he was discriminated upon because of his sex. Bostock's argument loses in the trial court. It loses in the appellate court. But the Supreme Court grants cert, and they hear his case. They also hear a couple of other plaintiffs, Zarda and Stevens. Both had similar situations. They alleged that they were fired for their sexual orientation. Stevens specifically was transgender. So all three plaintiffs are consolidated before the court. The court has a question before it. Does Title VII prohibit an employer from discriminating against an employee because of their sexual orientation? Now, the lawyers for Bostock are incredibly clever. They make a textual argument. They know that they have to appeal to a textualist court to win this case. They make a textual argument that the word sex cannot be unlinked from sexual orientation. Now, the way they do this is they put forth an example about a husband named Bill. They say that there could be two employees with husbands named Bill. One is a man and the other is a woman. Now, if you fire the man but you don't fire the woman, you are discriminating upon sex. You're not discriminating upon the sexual behavior, the sexual orientation. You are actually discriminating directly upon sex. And this is the argument that Justice Gorsuch and the majority find appealing, and it's the argument that they accept. So they say that you cannot delink sex from sexual orientation. If you're going to discriminate on sexual orientation, you are necessarily going to be discriminating upon sex. So it's a textualist argument. It doesn't really rely heavily on the legislative history, and that's because it's not really in the plaintiff's court, and we'll discuss that in the Alito dissent. But the decision relies on a sort of hyper-textualism, where you take a word and you look at the meaning of the word and all of the potential consequences that could come from it, because that law, and Gorsuch basically says that we are going to regard the text as the ultimate source of the law. We're not going to look so much to the legislative history or to the meaning of the word sex when it was passed in the 1964 Civil Rights Act, but what we're going to look at is strictly the consequences that the word sex has in the real world. And because of this inability to delink sex and sexual orientation in employment, hiring and firing, we are going to say that, yeah, Bostock, you win. You cannot discriminate upon someone because of their sexual orientation or their transgender, because Title VII of the Civil Rights Act prohibits it based upon the word sex. So that's the majority opinion. There's two dissents. Kavanaugh writes a dissent that we'll just bust into quickly. In Kavanaugh's dissent, he says that this is basically a separation of powers argument. Congress had tried to include the word sexual orientation in the law in the past, and it had been unsuccessful in doing so. And because it hadn't included sexual orientation into Title VII, Congress didn't intend for employers to be bound by not being able to discriminate against homosexuals or transgenders. So he argues heavily to the legislative history, saying that the Congress in 1964, they didn't really mean to encompass these types of plaintiffs, and they didn't really mean to protect them, and for that reason, we as a court should not be legislating. He does have a nice paragraph at the end where he says, this is a clever argument. I'm basically glad that the homosexual community and the transgender community get this win and they won't be discriminated against anymore. Now, Justice Alito, he doesn't really have the nice paragraph at the end. Him and Justice Thomas write a dissent. They focus primarily, let's start off by what he calls Gorsuch's form of textualism. He calls it a pirate ship flying a Scalia flag when truly it's underground. It is not the true textualism of Scalia. He basically invokes Scalia throughout his opinion, and he invokes the principle that Scalia articulated where he says, we should interpret a statute with the ordinary meaning. We should interpret the words in a statute with the ordinary meaning that a reasonable person would have given them at the time the statute passed. Now, Alito is saying the word sex, the ordinary meaning of the word sex when the 1964 Civil Rights Act did not encompass sexual orientation. He points also to the legislative history. He points to the history of the time. He says that in 1964, basically homosexuality was thought of as a mental illness. It wasn't thought of as we think of it today. And he says that there's no way that the Congress in 1964 meant to encompass sexual orientation in the Civil Rights Act. So that's the crux of his argument. He relies heavily on Scalia. He wants to counter the argument that the majority finds persuasive, the two-bill husband argument. And what he says is, we could add two women to this, and a woman who marries a man and a woman who marries a woman. Now, if we look at those four people and an employer decides to not hire the two of them that married their own sex, that employer is not discriminating upon sex. He's actually discriminating upon sexual orientation. And sexual orientation wasn't included by the Congress in the Civil Rights Act in Title VII. It might be unfortunate that employers can still discriminate on sexual orientation, but Congress didn't include that in its 1964 Civil Rights Act. So we as a judiciary should not be legislating. So that's the case. Three different opinions. I think you see a divide here with the Alito and the Thomas dissent and the Gorsuch majority opinion in textualism. Now, textualism, according to Alito, means we need to look at the legislative history and look at what the ordinary meaning of the words would have been when the statute was passed by Congress, so in 1964. Whereas Gorsuch kind of takes a sense, in a sense, a hyperliteralism. We are just going to look at the words on the statute, and whatever consequences those words on the law or in the law have, then that's what we need to accept. We need to look directly at the words and their meaning in the law, and we don't need to focus so heavily upon the ordinary meaning of the legislature when the statute was passed. So you kind of see a divide in two theories of textualism. And that is interesting because you could think that all textualists are in the same camp, but Gorsuch shows here a very different brand of textualism than Alito, Thomas, Kavanaugh, and maybe even Scalia as they invoke. So that's interesting. I'd like to just posit a quick hypothetical where the argument that was accepted by the majority is that you can't delink sex from sexual orientation. So if you discriminate upon sexual orientation, you're necessarily discriminating upon sex. So I have a brief hypothetical. Let's say that there are two men. Both of these men want to basically have sexual relationships with multiple women. Okay. One guy is a polygamous type character, kind of egregious. We don't really like polygamists in our society. It's one man. Let's call him Cody. And Cody has 5 sister wives, right? Or let's just say 3 sister wives. And then we have another man. We'll call him Bill for ease of it. Bill lives in New York City, and Bill likes to have sexual relationships with multiple women, but he's never gotten married to them. Now, the reason why Cody got married to these women, they both had the same desire to have sexual relationship with multiple women. The reason Cody got married to these women is because he's a member of a religion that requires marriage before sex is allowed. Right now, and that religion, let's just say, also allows polygamy. Now, let's look at Bill in New York. He's not a member of a religion, but he has the same sexual relationships with all these 3 women in New York City. He links up with one on a Tuesday, one on a Thursday, one on a Saturday, right? So they both have sexual relationships with multiple women, but one is married, and Cody's necessarily married because of his religion. He wouldn't be married if it weren't for his membership in this faith, but because he's a member of this faith, now he's married. So now in essence, would Cody have a claim if he was discriminated against, if he wasn't hired, but Bill was hired for the job, right? Both men have sexual relationships with multiple women. Only reason Cody is married is because of his religion. Bill isn't married because he's not a member of a religion. And Cody's not hired because he's married to these women, whereas Bill is hired because he has no marriage, right? Now, I think you can see that what I'm trying to show here, what I'm trying to shine some light on, is that if we interpret religion directly and we look for an example like that, well, then that would be actually discrimination based upon religion. It's not discrimination based upon the fact that they have multiple spouses, because if you hire Bill, Bill has multiple sexual partners as well. They both have multiple sexual partners. So kind of a stretch, but I wanted to try and think of something that could show where maybe the majority's opinion could lead to something that we might not think of intuitively as right. I think most of us agree that homosexuals should be recognized by the law at this point, but a lot of people don't agree with that sentiment when applied to polygamy. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.